It's okay, the voice? Or sure? So let's start very quickly because it's just 10 minutes. So I'm going to talk a little bit about this system we have in Spain of administrative protection of copyright directed to online copyright infringement, which is called the Cindy-Bertlo IP Commission. So it was named after two Spanish ministers, culture ministers, and it's in a specific provision within a general law, and secondary legislation was passed in December 11th and it's in force from March 2012. Recently has been amended, and that's part of the interest, through the new reform of the Spanish Copyright Act, and that includes new powers for this IT Commission and the possibility of going against intermediaries, including payment service intermediaries and advertising service providers. So the main concern was that was going against the online copyright infringement, especially through websites providing links to infringing content. So the policy decisions behind the law were that the decision was not going against the individual users, but instead targeting information service providers, so providers with an economic activity and information providers within the definition of the e-commerce directive. And then, of course, requiring the cooperation, the compulsory cooperation of intermediaries. Again, initially, mostly the information society services, the intermediary information society services, but then also including new type of intermediaries. And why administrative enforcement? This is my version, but I think this is yes. This is one of the motives behind, maybe unspoken, but right holders have been largely unsuccessful in going judicially against these pirate websites. Mostly because at that time, in many cases, not all the time, but in many cases, judges had concluded that, linking is not a communication to the public, and then there is no copyright infringement there, and it's just a facilitation to infringement, which would not be an infringement under the Spanish Copyright Act that didn't include at that time secondary liability or secondary infringement. And then it was kind of a controversial move of saying, okay, judges are saying this is not an infringement, let's set up a government body that will know what an infringement is and will know better than judges, in a way. But largely that was the purpose behind the law. But there are some problems, there are limits in administrative enforcement, especially because in Spain there is a high protection for freedom of expression, specifically requiring the participation of the judge when it comes to seizure of publication, recordings, and so on. So finally, it was established a light system of judicial authorization, which means that the enforcement measures must be authorized after the fact, authorized by a judge, but the judge can only consider whether those measures, for instance, website blocking, would affect freedom of expression. But the judge cannot consider or decide whether there was or not an infringement of copyright in the first place. Okay? So the procedure seeks exclusively injunctive relief, not monetary relief, and it's considered as a procedure for re-establishing legality. Okay? So the provider is ordered to remove the content in the case of a hosting provider or disable the access to it, and then if it doesn't comply, injunctions may be issued against intermediaries. And in practice, only those forced means of enforcement are the ones that require the judicial authorization. And that was a novelty under Spanish law, this type of administrative control. And the idea was for the law to take advantage of a provision in the implementation of the e-commerce directive, which was Article 8, that implements the limitations on the control of origin. You remember, if you are familiar with that, with the directive, that Article 3.4 allows member states to take measures against information society services which prejudice or present serious risk of prejudice to a number of objectives, and that was listed similarly in Article 8 of the Spanish transposition, including a criminal investigation, public health, human dignity, and so on, this particular objective. So, as that implementation norm provides for the possibility of adopting restriction measures in those cases, not just for services coming from other member states, but also from services provided within Spain, and that allowed the competent authority to ask the cooperation of intermediaries, and the authority could be also an administrative one, because the article does not require the authority must be a judge. Then the idea was simply to add a new objective. So the information society services could also be restricted when they go against the protection of intellectual property. By the way, we in Spain by intellectual property mean exclusively copyright and related rights. So our Intellectual Property Act or law refers exclusively to this, and for patents and trademarks we call that industrial property, and we have separate laws. So, and then the single law created a administrative body that will have this power, and which is the second section of this commission, which is not an independent authority, but all members are appointed by government among civil servants. And they are targeting information society services, and more specifically, after the last year reform, the procedure goes against information society service providers who violate IP rights, and the Commission may weigh whether the number of infringing works is sufficient or which is the business model. And then those who provide the description or location of the works, apparently offered without authorization, and is taking a non-neutral role in that activity. And particularly those websites providing classified lists of links to protected works, regardless of the fact that the links may be initially provided by users. And so very quickly, there's a complaint by the right holder after an unsuccessful attempt to require the provider to remove or disable the contents. Then, interestingly, this attempt will mean that the provider will have the actual knowledge under the e-commerce directive, okay, for the purposes of the Spanish transposition. Then either the provider voluntarily removes the content or makes the allegations about the existence of an exception or authorization. And if it does not remove, that if the provider removes, this will be understood as an acknowledgement of the infringement by that provider. This is a pretty tough idea. But then, if it doesn't remove, the Commission may order that removal, and there are sanctions in case of failing to comply with that. And then information society service intermediaries, including now payment and advertising, may be required to remove to comply with that. Okay, this is an interesting thing. If the website operates under the .es, the IP Commission will order the registration authority in Spain to cancel that domain name registration directly. Okay, and then the measures against intermediaries need that authorization from the judge. The Commission asks the judge. The judge cannot consider whether there is an underlying infringement, only if it affects freedom of expression and other related rights. And so far there have been very few results. In practice, it has resulted in a very convoluted and slow procedure, much more than expected. So right owners are, in a way, frustrated with that. A number of websites complied voluntarily, and two cases that may be worth mention. GoEar was the first case where an authorization was asked for, and the judge denied that for lack of proportionality. But then on appeal, it was finally granted. But anyway, the web is accessible because it's located in another country, so this is clearly ineffective. And then, more recently, it was authorized that Spanish ISP would block the Pirate Bay in Spain, which is the case now. So that was the Pirate Bay in Spain and is no longer accessible. And maybe that's it. Maybe that question of whether or not linking entails an infringement may be moot now after Svensson and after also the reform of the Copyright Act, which expressly considers that an infringement and includes secondary liability and also criminal liability for that. That's it. Thank you very much.